for the benefit of your classmates who couldn't be here. An overview of what we're going to be talking about in Module 2. We're going to defend a statement of consideration. Consideration being one of the three elements of a valid contract. A valid contract has offer, acceptance, and consideration, but it doesn't have to be in writing. That's based on the very old English common law, which is hundreds and hundreds of years old, and it still applies today. We're going to learn how to create an intake form based on a written scenario or legal case, rewrite contract terms based on an intake form, correct defective terms using an intake form, research possible remedies for breach in a business contract situation. Does that sound fun? And as you know, your assignments for this week are to read chapters 3 and 12 in the book Contract for Paralegals. Has anyone read the textbook yet? What do you think about the textbook? Any opinions?
I personally really like it. It's really interesting to me. I haven't taken a class like this before, so I thought it was interesting to read and just get some more knowledge on the subject.
Yeah, law is a very different way of thinking. And I can tell you, everyone that I went to law school with, everybody freaked out their first term. You know, I freaked out. Everybody freaks out because it's so different than anything that we've ever been introduced to before. But I do believe that this textbook is excellent. It explains everything to me in a very clear and straightforward way. The restatement second of contracts, that is, the restatement is a horn book. It's a treatise. I meant to take a horn book out to show you, but it's just like an encyclopedia of the law. It's what we consider a secondary legal source. A primary source of the law would be the U.S. Constitution, statutes, state and federal statutes, and cases, rules that have been promulgated by a legislative or administrative authority. That would be a primary source of the law. Cases, statutes, constitutions. Anything after that is someone talking about the law. And a restatement of contracts is like an encyclopedia talking about the law. We consider that a secondary source of law. Not quite as pure as the primary source of law, but you could still cite to it. The Uniform Commercial Code is what we'll be getting into this week. The Uniform Commercial Code is a source of law that specifically applies to contracts for the sale of goods. So when you're selling goods in the stream of commerce, there's certain principles that apply because we want to uphold contracts for the sale of goods because it's very important to our domestic and global economy. So there's a relaxation on certain rules under the Uniform Commercial Code to encourage the free flow of commerce. So most states have adopted the Uniform Commercial Code and put it into their statutes. So the Uniform Commercial Code is primary law. So anytime you're working as a paralegal or as an attorney and you have a customer who is your client is dealing with the sale or of goods. Like I had a client once who was a wine distributor, and the case we were working on all had to do with the distribution of bottles of wine to various retail outlets. That contract was governed by the Uniform Commercial Code because wine is considered a good. If you had a contract for the purchase of a computer, a laptop, that is a good. And distinguishing this from a contract for services. A contract for services would not be governed by the Uniform Commercial Code because those special rules would not need to apply. For example, if I hired Britney Spears, Free Britney, if I hired Britney Spears to sing at my birthday party, that's a personal services contract. It would be governed by the common law, the good old-fashioned common law. The Uniform Commercial Code would not apply to a service contract like that. So we'll get more into it as we go along through this lecture. But the UCC has special rules for what remedies are available to buyers and sellers in the event of a breach of contract. Again, this is all to ensure the smoothness of commercial transactions, because you can see from our robust modern economy, it is very important that we have the free flow and sale and purchase of goods to keep that economy strong and robust. So, let's take a look at some of the buyers and sellers remedies in the event of a breach of contract. So usually the parties to a sale contract, or could be a lease, because sometimes people lease goods. They lease cars, they lease lawnmowers. Sometimes people lease things instead of buy them. So the parties to the sale or lease of a contract owe a duty to perform the obligations as specified in the agreement. That is set forth in these two UCC provisions. The seller's general obligation under the UCC is to transfer and deliver the goods to the buyer. So if I buy a Microsoft computer on the internet, the seller's obligation is to transfer ownership of that computer to me and deliver it to my door. And if they fail to do that, then the seller has breached its obligations under the UCC, and I can sue for breach of contract. The buyer's obligation is to what, Unica? What is the buyer required to do?
Says accept and pay for the goods.
Yeah, and it's common sense, right? If you bought a book on the internet, you have to pay for it. That's the whole point of capitalism. That's what keeps our economy thriving, is the constant exchange of consideration and goods flowing through free commerce and free open global markets. So the seller has to transfer and deliver the goods. The buyer has to accept and pay for the goods. When one party breaches a sales contract, the UCC provides the injured party with a variety of pre-litigation and litigation remedies. These remedies are designed to place the injured party in as good a position as if the breaching party's contractual obligations were fully performed. And again, that's specified in the UCC. The best remedy will depend on the circumstances of your particular case. So the UCC affords flexibility, Unica. So if your client would like to exercise one particular remedy but not another, that's okay, as long as it's one of the remedies that the UCC allows. The performance of obligations and remedies available for breach of sales and lease contracts are discussed in Chapter 12 of your textbook. Tender. What does the seller have to do? Well, the seller has an obligation: tender, delivery, or transfer and deliver the goods to the buyer in accordance with a sales or lease contract. It's the seller's basic obligation under UCC 2-301. So let's say that your client is a business that constructs houses, and your client has purchased 1,000 nails from a particular seller. The seller's obligation is to deliver those goods to the buyer in accordance with the contract. That's the seller's obligation. If the seller fails to do that, that'd be breach of contract. Tender of delivery requires the seller to put and hold conforming goods at the buyer's or lessee's disposition and give the buyer or lessee any notification reasonably necessary to enable delivery of the goods. The parties may agree as to the time, place, and manner of delivery. Seller's performance. The UCC gives a seller who delivers non-conforming goods an opportunity to cure the non-conformity. So this happens a lot. Somebody purchases tablecloths maybe for a restaurant. So somebody owns a franchise and they own several restaurants, and it's like a Pizza Hut where they need a red and white tablecloth, and they order 1,000 red and white tablecloths. Well, the seller sends blue and white checkered tablecloths. That's non-conforming goods. What happens in that case, Natalie, if the seller sends the buyer non-conforming goods? What happens?
Don't they have to like send it back? And I think I could be completely wrong, but don't they pay for it, or they send back, you send back what didn't work and then they would send you the correct one?
Exactly. Under the UCC, the seller who delivers nonconforming goods gets an opportunity to cure the nonconformity. Although the term cure is not defined by the UCC, it generally means an opportunity to repair or replace defective or nonconforming goods. A cure may be attempted if the time for performance has not expired and the seller or lessor notifies the buyer or the lessee of his or her intention to make a conforming delivery within the contract time. So the buyer does need to notify the seller of the nonconformity. Let's talk about the buyer's obligations under the UCC. Once the seller has properly tendered delivery, the buyer is obligated, as Unica said, to accept and pay for the goods in accordance with the contract. If there is no agreement as to how this is going to be performed, then the UCC provisions will control. There's a right of inspection. The buyer has the right to inspect the goods that are tendered, delivered, or identified in the sale contract prior to accepting or paying for them. So in the case of, say, a restaurant ordering red and white checkered tablecloths for the business, it has an opportunity to inspect those goods, open up the box and look at them. And before it pays for them, and if the goods are non-conforming, the buyer does not have to accept or pay for them. If the goods are shipped, the inspection may take place after their arrival. If the inspected goods do not conform to the contract, the buyer may reject them without paying for them under UCC 2-513. Any questions? All righty. You all are smart and you're getting this. All right, so what does the buyer have to do? Pay. Goods that are accepted must be paid for under UCC 2-607. Unless the parties to a contract agree otherwise, payment is due from a buyer when and where the goods are delivered, even if the place of delivery is the same as the place of shipment. Buyers often purchase goods on credit extended by the seller. Unless the parties agree to other terms, the credit period begins to run from the time the goods are shipped. And oftentimes that will happen, especially when the parties have been doing business for a long time. The seller will extend a certain amount of credit to the buyer, and the buyer, doesn't have to pay immediately because they're purchasing goods on credit. What are the buyer's remedies? Well, revocation of acceptance. A buyer who has accepted goods may subsequently revoke his or her acceptance if the goods are non-conforming, or if the nonconformity substantially impairs the value of the goods to the buyer, and one of the following factors is shown: the seller or the seller's promise to timely cure the nonconformity is not met, the goods were accepted before the nonconformity was discovered, and the nonconformity was difficult to discover, or the goods were accepted before the nonconformity was discovered, and the seller assured the buyers, hey, these goods are conforming, just take this box. We're gone. Here, accept this box, accept this delivery, the goods are okay. In that instance, if the buyer inspects the goods and finds out that they are non-conforming, the buyer can revoke acceptance. Right to withhold delivery. Delivery of goods may be withheld if the seller or the lessor is in possession of them when the buyer or the lessee breaches the contract. This remedy is available if the buyer wrongfully rejects or revokes acceptance of the good, fails to make payment when due, or repudiates the contract. If the part of goods under the contract has been delivered when the buyer materially breaches, the seller may withhold delivery of the remainder of the goods. One way this occurs is a seller who discovers the buyer is insolvent, has filed for bankruptcy before the goods are delivered, may refuse to deliver as promised unless the buyer pays cash on delivery. Any questions, Giselle? What do you think about all this? One thing about the law in the beginning is a lot of it is just going to be getting down in these rules, because once you learn what the rules are, Then you can apply them and reach a conclusion. And we're going to talk about the Iraq process later. But we're talking about issues now, and we're learning rules, because these are the rules that you'll need to apply in your Module 2 assignment to reach a conclusion about how you should proceed with a particular client. So it's this, at this stage in your education, is going to be learning a lot of rules. Okay, great. So let's go over the buyer's remedies. The UCC provides a variety of remedies to a buyer upon the seller's breach of a sales contract. So this is what the buyer's remedies are. So if you are representing a buyer in a breach of contract action, this is what you could tell your client. Well, you have the right to reject non-conforming goods or improperly tendered goods. You have a right to recover goods from an insolvent seller. You have the right to obtain specific performance, which is when the court orders the seller to perform the contract and hand over the goods. This is usually required when the goods are rare, like a rare piece of art, antiques, or rare coins. The buyer has the right to cover, which means obtain substitute goods from another seller, which would normally work if you're just trying to, purchase ordinary goods, nails, supplies, napkins, paper towels. If one seller does not deliver conforming goods, the buyer has a right, and in some cases a duty, to get substitute goods from another seller to reduce your damages. The buyer can cancel, and of course, the right to sue for money damages. Okay, Unica, what would you want your client to do in the event of a breach of contract? Which one of these remedies would you recommend?
Um, if they breached my contract,
If the seller breaches a contract to deliver certain goods that you've ordered, what would you recommend? What would you do? Or if it was your client, what would you recommend that your client do?
I would do number 5.
Cancel?
Um, yeah, I would cancel. I know you can do 2, like you could like recover the goods. Is that what that's saying? Like you still
Yes.
want to move forward and be like, hey, you didn't send me my stuff. But I mean, I've done that so many times with Amazon and it just creates more issues and then you're waiting and waiting. Just cancel it and give me my money back. I don't want to have to sue. So I would suggest number 5.
You were smart. Yeah, that I used to be a seller on Amazon, and I was a seller on eBay for a while. There was a time about maybe 10 or 15 years ago when I decided to put up a little storefront on eBay and Amazon. And and through my own purchases there too, I've found that if there's a problem, it's just easier to cancel and start a brand new transaction with someone else who is reliable, and avoid all the confusion and the bickering and the back and forth. Just walk away and start all over again with someone new, right? Yeah, and never use that sender again. Exactly, exactly. And leave a review. Yep. Yeah, when I was a seller on eBay, I had like a perfect review, but I had one or two issues on Amazon. Okay, yeah. So that's the great thing about the UCC, is that the buyer has options, many options. And most of the things that you're buying and selling on the internet would be goods. Most of the stuff that I buy on Amazon. And I do prefer to shop on Amazon because it is easier to get a remedy, right? You can get your account credited the same day you have a problem with Amazon. It's very easy to get a remedy. It's a little bit harder with other people. Anyone else have any thoughts on this? How buyers can get remedies when you purchase goods? Has anyone purchased something at Target or Walmart.com or Amazon and had a difficulty getting a remedy? Any issues? I bought some stuff on
I
one wall.
oh.
Go ahead.
I was gonna say when the pandemic hit last year and everybody was on Amazon buying all of these survival things. I mean, I did too. And it literally, I was waiting for stuff for months or some stuff that never even came. So I found myself 6 months later having to go back, and then they're like, "Oh, we don't even see the order." I think because there was just so much going on at that time last year. So it's stuff like that I've had issues with. And like I said, I always just cancel it and then just use somebody else because I don't like the hassle. And there's so many other senders who are selling the same product. So to me, I would never sue just because it's so minute. You can always find somebody else who will be selling for what you want and maybe even a better deal.
Good, good. I experienced that too during the pandemic. I bought a couple of I bought some air purifiers from Walmart, and it was very difficult to return them once I realized it wasn't the air purifier that I wanted because Walmart made it difficult to return items during the pandemic and the health regulation this, we can't take anything back. So I just said, you know what? I'm not going to be buying very much from Walmart anymore. I'm going to be buying it from Amazon because they have an easy return policy. In fact, I bought an office chair from Amazon. It was too big. Amazon told me to keep the office chair and they gave me my refund. So yeah, that's the kind of customer service that I like. So yeah, my purchases to Walmart have dwindled, dwindled, dwindled. Target the same way. I was buying things from Target, but again, once I realized I could get it faster from Walmart, I just paid that Target credit card off, cut it up. I do not hardly buy anything anymore from Target because it's easier with one click on Amazon for me to get what I want. Amazon Prime, I get it the next day. Some Amazon stuff can even be delivered the same day. And it was so much easier. Yeah. And when I do need to return something, all I have to do is take it to the store, Whole Foods, right down the street. I mean, it's so much easier to get a remedy from Amazon, and I'm not able to get those remedies from places like Target and Walmart when they're telling me, "Oh, we can't take anything back during the pandemic." You know, hmm, that means I won't be buying from you guys. Okay, so this table is a great summary of the remedies that are possible. So the situation here, the seller refuses to deliver the goods or delivers non-conforming goods that the buyer does not want. So there's a summary of remedies. The seller tenders non-conforming goods and the buyer accepts them. The seller refuses to deliver goods and the buyer wants them. So these are the remedies. These are the buyer's remedies. And I believe there's a quiz in module 3, and you'll need to know this for that quiz. Let's talk about our written assignment. So we're going to consider a scenario. The buyer and seller have a master contract. 20 customized parts have been ordered from careful seller by the buyer. Customized and specialized parts for $1,000 a part. They are customized with painted advertising for the buyer. 20 parts have been shipped. The buyer rejected 10 and accepted 10, but did not pay for any of the parts. The buyer held all the parts for 10 days and then returned the 10 rejected parts with a message saying they were too large and said that the buyer intended to use only the 10 that they liked and then cover with another company to get the other 10 parts. Do you see any problems with this? Buyer, sure, let me repeat the scenario. The buyer has ordered 20 customized parts. The seller sends 10 conforming, 10 non-conforming. The buyer sends 10 of them back and says, I am going to cover with a different person. What's wrong, Natalie?
So it says in there that they're customized. So if he said they were too large, if he had ordered like customized parts, like let's say it was for a car, and you order customized parts, they should fit. I mean, sometimes like people may have judged it or whatever, but I just think if they were customized, they should have fit. and he should have at least paid for the 10 that he did accept rather than just not paying at all.
Okay, so yeah, let's go back to the UCC provisions. UCC 2-508 gives a seller who delivers non-conforming goods an opportunity to cure. It generally means an opportunity to repair or replace the defective or non-conforming goods. In our scenario, did the buyer give the seller an opportunity to cure? No, Natalie. And again, the purpose of the UCC is really to uphold contracts, because contracts are extremely important to a commercial marketplace. We need to have people making contracts for the sale of goods, and we need to have those contracts be enforced just to keep the economy thriving. So um, we want to uphold this contract. We want to give the seller an opportunity to cure. So in this scenario, the buyer held the parts for 10 days, returned the 10 rejected parts with a message that said they were too large for use, and the buyer intends to use the acceptable ones and obtain cover for the other 10 parts from a different company. So the seller has the full right to cure any defect in the parts within 10 days of notification of the defect to the seller and return of the defective parts. If the seller does not cure within 10 days, the buyer may obtain cover parts from any other source. So that's in the contract. The contract says the seller has the right to cure any defect in the parts within 10 days of notification of the defect to the seller and the return of the defective parts. If the seller does not cure within 10 days, the buyer may obtain cover parts from another source. This paragraph is not intended to add or change a UCC remedy other than to give time limits. So when parties agree to a contract for the sale of goods, they can add in any provision they want as long as it doesn't conflict with the UCC. But they can specify time limits for cure, time limits for delivery, time limits to tender, payments, things like that. The parties can be silent in the contract about the right to cure, because no matter what is written in the contract, the UCC applies to contracts for the sale of goods, regardless of what is in writing. The parties can use the contract to clarify certain issues, but it can't really change it. And that's why this paragraph is not intended to add to or change a UCC remedy. So your assignment is to define cover and cure in your own words in the context of this contract. Cite a section of the law that you were paraphrasing, and that's a primary source of law. It can be the UCC provision in your state. It could be a case that is talking about the UCC. Those would be a primary source of law. Complete the italicized portions of the IRAC table. Use the scenario, the UCC, and the contract to complete the table. And then try to select a way to fix clause 3 of the master contract. Explain why you made this fix. So let's look at this second part. Let's look at the partially completed IRAC table. So you will need to fill out the IRAC table for this assignment. And here's the IRAC table. First issue: is it legal under the UCC for Ann Daniels to offer to cure shipment? And then you need to find the rule. So you have to fill in the italicized portion in blue. The application: if careful seller cures the shipment, the buyer would have 10 parts that are conforming, and then your conclusion. So this is a way to learn to do the IRAC format, which you have to do in law school as well. So the issue has been identified. You find the rule. Here's your application, and then you need to reach the conclusion. So in this particular Yeah, when I was in law school, Iraq wasn't my favorite thing either. And to be honest, when I started teaching this class and I saw Iraq, I was like, ugh. I even thought to myself, I was like, I'm teaching this class. I wonder if there's a way I could take Iraq out of it. And then I realized, no, Iraq is still valid. And for those of you who will be going to law school, you do need to know how to use it. It is a method for approaching legal problem thinking. So simply put, what IRAC is, Unica, is a way of analyzing a legal problem. The first thing you do is identify the issue. We just identified one of the issues in the scenario was the seller's right to cure, right? In the scenario, the buyer said, here's your non-conforming good back. I'm about to go get some cover goods from someone else. So the legal question is there a right to cure? That's the issue. Now, what we need to do is find the rule that talks about cure. Yes, that's exactly it. Yes. It is a shortened version of a legal memo. It's a hands-on worksheet that could be the basis of a legal memo, Unica. It is. It's another way of writing your memo. It's just a worksheet for you to jot down ideas. It needs to be formatted as a memo, Natalie. You bet. Now, the first part, you will need to use your flexibility. Let me go back to the assignment. One of the great things in life and in law is that there's not always one hard and fast way to do things, but there's a flexibility. So notice the first question is simply to define and cover and cure. You don't have to IRAC that. You just have to say, this is my module 2 written assignment. And the first part of it is an essay where you define cover and cure in your own words and then cite to the provision of the UCC. Then the next part is to complete, with my phone ringing. It's a nice song, nice ringtone. Okay, surely that was a scam. Okay, so the next part of your assignment that you'll be submitting is to complete the italicized portions of the IRAC table. You would not necessarily need to write that in an essay if you don't want to. Do exactly what the assignment asks. Define cover and cure in your own words. The next part of your answer will be to complete the italicized portions of the IRAC table. You do not need to write an essay repeating what's in the IRAC table unless you want to. The next part of the assignment is just to simply write a paragraph fixing clause 3 of the master contract. So the easiest way to do this would simply just be to answer those questions in a double-spaced document and follow the Blue Book format. Does that clear up any questions? Flexibility is always required.
Okay. I have a question because I was so lost last week. So for the assignment is we're going to complete the table,
Yep.
and so that's the second bullet point. And then you
Yes.
said the third bullet point is just a paragraph fixing clause 3 in a double spaced document.
Yep.
And then the first point, is that the legal memo?
No memo has to be written. You can do
Oh, we
this
don't
all
have
in one document. All you need is a Microsoft Word document that defines the word cover, defines the word cure, cites to the UCC provision. In that document, or you could submit 2 documents, you need to complete that IRAC table. And then the third thing you need to do is submit a document a paragraph fixing clause 3. Some people put this all in one piece of paper. Some people put this in two pieces of paper, one answering part 1 and 3, and and then they keep the IRAC table as a separate document. Some people put all that together in one document.
Is and there's not a length requirement, right? Because last week it said
Yeah.
3 to 5.
No.
Okay.
Nope. All you have to do is answer this. I actually could see brief, brevity. Define the word cover. Define the word cure. That's pretty short. Select a fix for clause 3. That's pretty short. And then do the IRAC table. You're welcome. I've never been a very flexible person. I'm very inflexible. So, assignment, I can understand why the assignment's just, getting to you, because it's requiring you to flex, and to do different things, and to show your ability to do different skills all in one assignment. And by nature, I'm an inflexible person. So this assignment requires a little bit of flexibility. So let's get back to the IRAC table. So IRAC stands for issue, rule, your application of the rule to the facts, where you reach a conclusion. That's how we do legal analysis. It is very logical and it's very rule centered. You're given the issue, which we just talked about, is whether or not the buyer needs to give the seller an opportunity to cure. We talked about which rule that was. And then we just need to, if careful seller cures the shipment, then the buyer would have 20 parts that are conforming. So then your conclusion is, well, looks like the contract's been satisfied. There's no need to sue. So let's get down to this third part. Do a general search for measure of damages for breach of contract. You'll need to use Fast Case or Lexis Advance and sort for the most recent case. So what we're doing here is we are looking for the current case law talking about the measure of damages for breach of contract. When you do your search, I would actually suggest putting in measure of damages for breach of sales contract UCC. I would put that in there to give you a more on-point case. And then you always want to use the most recent case, because we want to know what the courts are saying now about UCC damages. So we just talked about the UCC rules for remedies, but now we want to see what a case is saying about the UCC damages. And this is where you will need to IRAC the case. So when you find your case, you will need to write the issue in the case, the rule that was cited in the case, the analysis, and the conclusion. Let me see if I can do a sample of this. Would that be helpful? Let me see if I can go into Fast Case and do this. Let's see if I can share a web browser and do this, because I'm curious myself to see what kind of results can be generated from this search. What I want is to go into the online classroom where I can see if I can, this is what I want. I'm going to do this search with you, and we're going to see what results we get. And I'm going to try to show you methodology for getting better results. Okay, this is our home page. Okay, so this is our assignment on remedies. You will need to IRAC the case that you find. click here to download the table. So what I want to do now is I want to go to our resources. So we can get, I want to go to our library resources, which is under books and tools. Go to our library resources. I want to go to Paralegal, School of Justice Studies. I want to go to Fast Case. There it is. Fast Case. What I like about Fast Case is it gives you a Google style search engine. Now it wants a password, username. I'm not going to give it a password, so we'll just do this another way. Can everyone still see my desktop? All right, cool. I'm just going to do, you'll do your search on Fastcase. I'm just going to search the open web. So what I'm going to search for is it said breach of contract, UCC, sales, remedies, cases. You can always search on the open web and get information, but you're going to get more information if you use the sources that you have access to. So here's information about breach of contract. All I want is a case that I can cite to. So you can see you can get quite a bit of information right here on the open web. Let's see if I can get a case. Here we go. This is a law review article. Here we go. Can everyone see my screen? Awesome. So I just found a case. Here's the case. You'll be looking for recent cases. So in Masterdom versus Mayor of Brooklyn, a New York case considered the leading American case on the subject of lost profit damages. The defendant argued that lost profits were too remote and speculative. The court disagreed and awarded the seller the difference between the contract price and the seller's cost of fulfilling the contract. The court held that no speculation was necessary because the cost of production could be established by using the market price of the elements of the seller's performance at the time of the breach. So that would be an example of a case talking about the issue of lost profits. So suppose that a buyer is purchasing water pumps to use and the seller does not deliver the water pumps, and that causes the buyer to be unable to operate its business, and it loses profits because it doesn't have any water pumps. It can't function. So the buyer could sue for lost profits in that scenario. And I would simply be citing to a case like this where the court says that lost profits are available in the event of a breach of contract. Okay, any questions? Yeah.
Yeah, I guess I'm confused again. So
Hmm.
for this, is this part of point one that we're defining, or cited section of the law you're paraphrasing? Is
No,
that part of that paragraph?
no. So this is when you're doing your IRAC form, there is a question. You can enter all the information, Unica, right into this form. Do a search using Lexis Advance or Fastcase. You have the passwords that allow you to access those. I don't. That's why I search Google instead. But you're going to use Fastcase or Lexis Advance because it's going to give you a very focused and recent case on the issue of damages. You have a ton of cases to pick from. Pick whichever one you like. When you get that case, do an IRAC on the case. Pick out the main issue, which should be about damages. Pick out the main rule that the court's saying, i.e., compensatory damages are available in the event of a breach of contract. You're basically going to summarize that case in one paragraph or two. You can do it right here in this form. Cite the Blue Book citation, give this the Blue Book citation. What damages could be awarded in court? How could you apply this to our scenario? And what would your conclusion be? So in this particular part of the table, it is asking you to find the law. It's asking you to research on Lexis Advance to find a case, extract the point of law from that case, give the citation, and then see if you can apply it to our scenario where the seller has shipped 10 conforming goods and 10 items that are not conforming. Does that make sense? Yep. So take what you're given is really how this works. And that is to complete the table. You might be used to writing memos. This assignment is not asking you to write a memo, though. This assignment is asking you to answer specific questions and to follow a format using this table. Sometimes our natural inclination to do something isn't right. So this assignment is asking you to do something else, which is to reason, learning how to reason through a legal problem using this table. All right, any more questions about that? I think it's going to be a fun assignment because it's really hands-on. It's filling out a table. It's easier than writing an essay on War and Peace. It's just learning how to solve a legal problem using the IRAC method where you identify the issue, you find the rule of law, you apply it to our facts, and you reach a conclusion. So let's talk about Iraq as opposed to Iraq. Iraq, the use of Iraq is popular among judges, attorneys, and students of the law. It is a way to show application and analysis in a clear way. Begin by reading the facts and determining the main issue. Complete research to determine the applicable rule. The rule must have an acceptable source that's cited. Analysis. Apply the rule to the facts of the case. You may find that the rule does not really work. If it does not, state that. Try a new IRAC with a rule that does apply. You won't have to get into all this detail because you're going to find the right rule. Missing facts called fact gaps should be typed into the application and analysis. We might get into that in Module 3. The type of facts that still need to be sought. Conclusion. The last step is to draw a conclusion based on your analysis, which is simply an answer to the original issue, which is going on in our case scenario. So it should be fun. Excuse me. Gosh, allergies. All right. So we've talked about complete the IRAC analysis using the form provided in the Module 2 written assignment. Unica has downloaded the form. Fill in the applicable UCC rule. Again, fill in your case that you find on Lexis Advance, and then add your conclusion. Be sure to take some time this week to read all of the lesson notes for Module 2, the importance of grammar and language, spotting errors. We'll talk more about that next week. And that's it. So this week, the live session is graded, Unica, and everyone needs to submit the correct answer to the live session question. So that's your only other assignment for this week. Is what does UCC 2-712 say? And you could Google that. Google UCC 2-712. Please submit the correct answer by Sunday, October 17th. Your Module 2 written assignment, which we just discussed, is also due on Sunday. If you have any questions, my e-door is always open. Call me on the phone, send me a text message, or email me. And have a great week. Any questions before we go? So please be sure to submit the correct answer to the live session question. That's how you get credit for the Module 2 live session assignment. Thank you, Unica. Thank you, Giselle. Thank you, Natalie, for taking the time out of your busy schedules to attend the live session. And I will see you all in cyberspace. Take care.